timber trespass. And we've invited Tim Lueders-Dumont, who works with the Vermont Department of State's attorneys and sheriffs, to join us. And he'll have, I think, a little bit to say at first, because he's been following our conversations on this bill. And then, of course, we'll be able to ask him some questions. So I don't know that you've been in the room that we're in now, the House Agriculture Committee, Agriculture, Food Resiliency and Forestry Committee. So maybe we should just introduce ourselves quickly. Representative Rice, would you lead us off?
Mike Rice, I represent the Bennington Rutland District, Danby, Dorset, Landgrove, Mount Tabor, and
John O'Brien, I represent Boylston and Tucker.
Esme Cole, Windsor 6, Hartford.
David Durfee, Shaftesbury, Sunderland, Glastonbury.
Rodney Graham, Williams, Chelsea.
Jed Lipsky, Lamoille Walnut Stowe.
David Templeman, Orleans 3, Brownington, Barton, and Westmore.
Okay. Well, Tim Lueders-Dumont, the Department of State's Attorneys and Sheriffs, and I spent a couple of years here in Washington County with now Judge Thibeault as a deputy state's attorney, including prosecution of home improvement fraud, which is timely here. And I just wanted to say it is nice to be on a sabbatical for judiciary committees. As I was just telling Mr. Chair, the atmosphere up here is very wholesome in many ways. And it is, the temperature up here is also much nicer than some of the committee rooms downstairs. So
Literal.
yes, and well, I'll let you take from that what you will. But I think the other thing I just wanted to say from the outset is that, you know, we have 21,600 pending criminal matters in our court system right now. They're being handled by 58 deputy state's attorneys and 14 state's attorneys. We are in an absolute crisis of resources, and the creation of new crimes and the allowance of new criminal code is something that we often look at with appreciation, because what we're trying to do is bring in more people that aren't being captured with respect to the victim population that you're talking about here. People that have approached individuals with a sale of goods. I'm going to help you with this. I'm going to do this for you. And then they don't do that and they walk away. And the enforcement measures of that are incredibly important. And with every aspect of enforcement, you need appropriate resources, training, specialty. I was having a conversation yesterday about humane officers and animal cruelty. And it's another gap, right, where we have, of the 21,000 cases, a small percentage would be that. And so while we have experts in domestic violence, experts in drug prosecution, experts in homicide prosecution, unfortunately, the ones that aren't bubbling up as much, sometimes they don't have the same level of expertise, resources, and training. So this would be an area just from the outset that I wanted to say, it would, and not for this committee necessarily, but for whether it's judiciary or appropriations, if it moves that way, that dedication of resources so that it can actually be enforced as opposed to just being a paper tiger would be really important. And for me, I've dealt with a few home improvement fraud cases. They were felonies, but they were nonviolent. And so because of that, they weren't making it to the top of the trial heap. With 14 buildings and 20, and if you include family cases that we cover, we have 26,000 cases. Things to make their way through our system are taking so long that, you know, this sort of bill is important because I do think it fills a gap in terms of the, it's not just timber trespass, it's improvements to lands that aren't being acted upon. You know, it's a breaking of a contract in a criminal nature, really, is what we're talking about. And I've talked with Representative Mahali about some of the constituents that he's spoken to, and I'm not surprised. We do have an issue not with the laws on our books, but with our ability to enforce them. And it's not a critique of prosecutors or law enforcement. Some of it's a labor shortage and the ability to hire in law enforcement. With state's attorneys, we're usually pretty good at filling our positions. But to accurately investigate something like this, it does take quite a bit of time. And what we're responding to is calls for service. Vermont is not, I'm telling you right now, except for murder cases and major assaultive cases, we do not have the resources to investigate crime. We are responding to emergent calls for service. And this is the type of crime where you would need, you know, documentation, potentially in 2024, potentially video surveillance of some of the activity at times. And you would need law enforcement to have some special training to make sure they're checking the boxes. And that's the same with home improvement fraud. And one of the sad stories of home improvement fraud is sometimes we're able to prove everything, but the person has no ability to pay back the restitution, $25,000 of damage to a roof. And so what ends up happening is you get these agreements, restitution agreements, where someone is paying $150 a month over 7 years with the restitution unit to try to make someone whole, as one of the only things we can do. So I just wanted to paint that bleak picture in this rosy committee that there are issues, and our staff have about 360 to 400 cases per person right now, the attorneys in our office. So we are asking for more positions. We think the judiciary system as a whole needs more resources and more space and time to do that. But with respect to this bill, I'd be happy to answer any questions. And the one area that I won't be able to talk to too much, in part because of some of the points I just made, is the seizure provisions. I know Attorney O'Grady went into that for about an hour the other day, I believe, and I actually found it quite instructive. The federal government does most of the seizure cases in Vermont. The vast majority involve drug distribution. And because of their mechanism with the federal angle, they have the ability to actually go in a much more effective manner. When I was in the treasurer's office, we, at one point, law enforcement dropped off money, or wanted to drop off money with biological matter on it, because it was a seizure and they didn't know where to put it. And I said, I don't think we want that in one of our vaults, which there's really only one. So all this to say, the seizure provisions, I think, until there is dedicated resources, may be borderline aspirational. Doesn't mean they're not important to have on the books. And I think there's some important updates that you've made here for people that are convicted, so that they can't go on and continue to do things. That's a really important consumer angle, which I know the Attorney General's office has done a really nice job on. One thing I wanted to talk about from the outset is the sentencing aspect of this. There's a reference to the word sentence in this, sentencing somebody. I would probably say the word conviction. I mean, it's a choice for you all. The likelihood of a person convicted of home improvement fraud, timber trespass, or land improvement fraud, as contemplated here, being incarcerated would be very, very slim. That's just my observation, and I won't speak on behalf of the judiciary, but judges exercise discretion, and even for assaultive, violent cases, there is not incarcerative sentences that are being handed down. And I know that you all are not necessarily steeped in that sentencing culture, but each case is analyzed very distinctly. The sentencing factors apply to only that case. And so we have had a case, Evan Meenan, our appellate attorney, who used to actually work for the Natural Resources Board, talked about a case, I think at one point, where there were some extra factors. It wasn't just that someone had stolen, land resources. There was some, whether it was an assault or someone kicked down a door, some factors that were not mitigating as to their sentence. So with that picture, those really my opening remarks. I'm happy to answer any questions about this. Yeah.
Representative Rice?
Yeah, we've heard sort of anecdotally throughout taking testimony on this several times with regard to seizure that we just have to do it once. Like, if we just get these guys, show them that we're serious, then the problem will sort of resolve itself. I just wonder if you want to react to that.
Yeah, I mean, I think what we would say from a law enforcement perspective would be that whether, and I am going to use a drug example, but interrupting whatever the activity is the point. Again, because it's maybe $11,000, $12,000 over the last 8 years that we've seized in terms of money seizures, as opposed to I think over $1 million from the federal government. Just shows you how little we're using that. Doesn't mean that it couldn't be improved. But I understand the policy reason for it. You want to take away the instruments of the crime so that they can't continue to go out and repeat that. Whether it's a repeat of that offender or just continuing on with their business, knowing that they've done it to somebody else. But I do think that having a person or a staff member in government, and I'm not going to say the agency for fear of getting an email afterwards, but an agency in government that has a dedicated person that becomes an expert in what you're talking about. The seizure prosecutor for the state of Vermont, that's what they do. They think about it 12 months out of the year, whenever it comes up in any county. And this is about, when you use Representative Arsenault's comment from the other day, if she ends up listening to this, but water the plants that you want to grow. We're in house agriculture. If you want someone to be great at seizures, staff a position. That person's the expert on it. They train law enforcement and they train prosecutors how to use that tool. Right now, what happens is it's catch as catch can. I got a home improvement fraud case. I got to get really good at this. So then you call people around, you call around the state. Having a dedicated resource is really important from a staffing perspective, and also that person creates a body of work in their own. And when they move along, they've created training materials, et cetera. So whether it's a statewide resource prosecutor that does seizure of assets in this context and in other contexts, it might be something to think about.
Are there other, did you call it a seizure prosecutor? Is that
Yes.
the term you used? And are there other examples of statewide specialists who could be a model for?
Yes, with some federal funding, we have traffic resource prosecutors. We have 2 people in our department that have federally funded grants that assist with the prosecution of traffic violations and DUIs. And they help train, they help provide advice in the field. So that way, if you're a brand new baby prosecutor and you often get all the DUIs, you have someone to call, and they're a resource of knowledge and practice.
Before I turn to Representative Templeman, I just wanted to go back also to the number that you mentioned, the difference between what the state has seized over a certain period of time and what the federal government has seized. And it was several orders of magnitude. It sounds like.
That's correct.
Yeah.
There was a report last year that we put out on this, on that topic. I'd be happy to send it to the committee.
Heard last, I think from Ledge Council, that we took a look at the percent, how the seized funds, assets are distributed, and I think it was 45% was split between the law enforcement agency and maybe the state's attorney's office and maybe the attorney general's office. I wonder whether in the case of federal seizure, there's a different percentage that might make some difference.
I would want to reference,
Have an impact.
yeah, I would want to reference the report. I know that number is in there off the top of my head. I'm not sure what that is. I think there's an equitable sharing agreement that goes on with the seizure of assets, including, I think, with federally seized. Yep.
Representative Templeman.
And so as we're trying to find teeth, to actually put some power behind this bill, from what we've heard prior and from what you're telling us now, maybe the seizure model isn't really the best way to approach this, if I'm understanding you correctly, without having the proper enforcement behind it. Can you suggest another model that may have more effective results?
I think, and the seizure model may well be helpful. I think it hasn't been utilized a whole lot. In part, I think one of the things you could consider, and whether it's this committee or another committee, one of the things you could consider is, what is the goal you're trying to achieve? Yes, we're trying to make victims whole. Yes, we're trying to deter the crime from occurring in the first place, and you're trying to stop it from happening. And so those really get to some of the core reason, the criminal justice kind of foundational principles. But there is also a rehabilitation aspect to the criminal justice system and the whole web of what we're trying to achieve. I think that question can be best answered by what is this bill trying to achieve? And if it is to make victims whole, then seizure of assets and assisting victims with that is helpful. Auctioning off things in the future, whatever the case may be, that's an important part. You have to put resources into whatever that is, and that means staff, time, training, and all. And I know you guys hear that all the time. It's like everyone comes into every committee and they say, you need more resources. But I think in particular, because we have proven that we're not using this tool very much now in drug forfeitures, that it may be particularly acute. Now we're getting into a new area. And if we're seizing as Representative Mahali told me, enormous equipment.
Right.
How do you get that equipment to and from? You need to contract with an individual that knows how to operate it and have VSP or a local agency there or the sheriff's there to make sure that everything's okay. How do you make sure they don't damage the equipment so that you can then sell it? I mean, there's just these could be massive investigations. And the point that I made last year on the paramilitary camp bill, it's the same thing. Lots of really great aim, right? You want to prevent people from potentially causing an insurrection and amassing firearms in an illegal manner. Great goal. To do that, you might need a confidential informant to infiltrate. You might need an individual to understand the nature of the firearms on that camp. Likewise here, you'll need a little bit of that technical expertise from someone in the industry probably to provide a lot of wherewithal about what can you even do with this equipment? Can it be used for something else? And I know the state does sell off old vehicles and stuff like that sometimes on auctions and things. So, but using that seizure for the purposes that you're trying to get out for the bill, that's what I would focus the attention on.
Oh, so you do think it's actually a worthy,
If it's resource appropriate.
but that's the issue.
Yeah.
And that seems to be the blocking point for this, because I mean, I see openings for law enforcement, and like you're saying, how burdened the judicial system is. We're not going to fix that necessarily overnight with the bill. Even if we put the money there just isn't the personnel to fill that position. So shy of that being the way we can do this, is there another way?
And I would need to think a little bit more
Okay,
about
fair enough.
that question, but I will chat with maybe some of our state's attorneys on if they think of another
Sure.
option. Yeah.
Representative Lipsky.
Yeah, thank you, counsel. I don't want to dwell a lot on this seizure issue. Mahali's bill has been a long time in coming, and this committee is very strongly supportive of its goals. I'm not big on seizure. I'm big on protecting landowners from this type of fraud and trespass. Getting them whole in a past tense is a big ask, but seizure will not do that in any sense of the word. There are people with perfected liens, lenders, they get their money. The state attorney's office and the state general fund gets the rest. The landowner gets zero. The victim gets zero. So that's not a big focus, but fixing the law and making the law have teeth to protect the interests of vulnerable landowners is our goal. And that's what I think, your point about focusing on conviction versus sentencing, as far as the Professional Loggers Council and others, we don't use the word sentencing because that's a dream. But convictions, which would, with a second conviction, makes it illegal for them to harvest.
And I'm going to tread into one area while you just mentioned that. If you want this conviction to matter in 20 years, you need to make sure it's not expungible or sealable.
Right. So just my perspective, I think the goals of the bill are clear. I don't want to get distracted with thinking we're going to save the world of seekers, because we've learned that's going to do nothing for the victim.
And with respect, I think that's the seizure provision could be helpful in the future to get at some of the other aims. Restitution is a different thing for victims. I will give an example of a case where I know that the victims were not necessarily happy with the way that it played out, but we did get them restitution. We had a home improvement fraud case. Someone started the work. They actually showed up quite a few times and then they disappeared, which is pretty common in those fact patterns. And we secured a restitution agreement where they would pay back an amount that myself and the defense attorney had agreed to. The victims wanted something resembling pain and suffering, but that's not what criminal court is for. That's what civil court is for. And so I had to tell them, this is the agreement that the state has come to. And it showed that we were able to get a result. They had a restitution agreement where they would get paid a considerable sum. And we knew that that was the outcome that we wanted. And I think focusing on the outcomes was important. I had to dismiss the case with prejudice, but I got the restitution agreement in order. And that was the negotiation. They weren't going to pay a dime until I dismissed the case without prejudice. And that meant that I could always bring the case back. Without prejudice means I could always bring it back. And I actually sent a calendar reminder to the person that took over my position so that they knew when the statute of limitations was going to come up. In case they had any future law enforcement interactions, the case would be refiled. There was some issues with the case from a facts perspective. There certainly was probable cause, and I thought that we could have prevailed at trial. But it was an example, for example, in a future situation, if you have land improvement fraud to fill that gap that you're talking about, It might be that there's some amount of damage that's been done to the property, you know, falling of trees and fences or whatever the case is. And the prosecutor might have to really focus on, what am I trying to get out of here? Do I want to get a conviction and go to trial? Maybe very limited pathway to do that in Vermont's current judiciary environment. Or do I want to try to pursue some restitution? You can pursue a restitution judgment order with or without a conviction, but it does need to be memorialized in writing according to the statute. And I've had a few instances where I've dismissed cases, but secured restitution for the victims. And so that's another, in terms of a policy practice thing, it does come up. But the restitution unit would want me to say that you do have to memorialize those in writing to make sure that basically the aims are accomplished. And I typically dismiss those without prejudice so that we could refile if we needed to. Just wanted to.
That's an existing,
That's correct.
no, we wouldn't need to write anything into this particular.
That's correct. I could foresee it coming up in land improvement fraud.
And just one follow-up, a lot of these thieves, there have been restitution agreements that are immediately defaulted on. They do not have assets, liquidity. And so you can get all the agreements you want, but will that serve the victims? I'm not as confident knowing you've got some desperate actors that sort of pathway.
That's one of the greatest limitations when you're dealing with restitution, is their actual ability to pay over time.
Stopping them from being able to commit this fraud or theft to begin with is a primary goal.
One of the things at arraignment that you could do is, in this case, I would put a special condition that they are to not, and there'd be arguments from the defense counsel that it's their livelihood, but I would always ask that they refrain from any activity relating to the crime, including doing the same type of work. With law enforcement officers that have been accused, we put conditions in that they're not to engage in law enforcement activity and then to turn in their firearms. So it's a similar type of thing. Restricting that in a condition of release is a piece of paper saying they can't do it. We don't have pretrial supervision in Vermont. We don't have the federal government's pretrial supervision. So the only way they would get caught in that circumstance, which is a massive conversation downstairs, is if police are basically checking in on them to make sure they're not doing it. Might be hard to hide given some of the sizes of the equipment that I understand they're operating, but they would get another criminal filing if they violated conditions of release if the prosecutor pursued that. So you can get conditions of release to limit what they're doing. The sheriff in Addison has a current pending criminal case, he's no longer the sheriff. But the conditions of release took away firearms, took away his ability to do certain law enforcement activity when he was accused of a crime.
So just between the new land improvement fraud provision, the seizure, the posting of a surety bond, given the current landscape and the backlog in cases, do those three factors or others that are in the bill give you a feeling that it would actually have an impact if this bill were to pass as it currently is written?
I think that it will have an impact. We would want to, what we do every year when there's new crimes is we do a training on the new crimes in June. Judges take a little vacation for their own judicial college. And we say, here are the new crimes that have put them in our system so they can be charged. And then we work with law enforcement to make sure that they're aware that they can now start doing these types of things. But the way it would probably come up is, oh, here's a situation where land improvement fraud now applies. And I think there is a gap that you're filling here in between timber trespass and home improvement fraud. Land improvement fraud is a gap. I like lining up a table, existing crimes, the new crime you're trying to do, doing a checkbox of seeing what are the gaps that you're trying to accomplish. And there are crimes, for example, attempted murder can often be charged as aggravated assault, right? So there is duplicative crimes in our system, but this one seems to be getting at something more broadly based on the fact patterns that I've heard described. And I think it could be very helpful as a tool, knowing that it may, because it's a nonviolent crime sort of at the onset, unless there's some other factors there, judges may not prioritize these cases in the criminal system. And there's many instances of that. Most misdemeanors are not getting any trial time.
Uh,
Doesn't mean you're not deterring the act though with law enforcement.
Representative O'Brien, then we should probably break. Go ahead.
Just because we're ag. I've learned a lot about sort of just jurisdictions here, so it sounds like the Attorney General's office deals with like the big 7 or big 12 or whatever, the violent crimes, right? Most of the other things fall to the Department of State Attorneys. This would fit with criminal, right? But then a lot of these cases, timber trespass or home improvement, start in the civil courts, like essentially, it's not like, oh, this thief stole my car and I have to bring a civil suit that this person, defendant stole my car. It immediately is a criminal case, right?
So there is an existing criminal law, the timber trespass, would start in criminal court. There's also a civil action, and you can always bring this law, the one you're creating with fraudulent, that's a new crime that you're adding to home improvement fraud would be in the criminal division. I will just say, just based on numbers and on the fact that our state's attorneys often ask me to say this, we are covering 99% of the criminal conduct in the state. The Department of State's attorneys, we're covering all 80 plus pending murders right now in the state, as well as 99% of the misdemeanors. We're doing the bulk of criminal law. The AG's office has other things that they do, many other things that they do. They have different divisions. So in terms of criminal law, we're doing the bulk of it in the state based on the data. And I presume most of these would sort of depend. If there was a really big type of event conjured by one of these situations, sometimes there is maybe a direct call to the AGO, but the first call is often to the county prosecutor where the situation took place. We share what's called concurrent jurisdiction entirely. See, the AG can do everything a state's attorney may do, is the way it's written in the law. So any filing we do, the attorney general may also do. Because of our locality and honestly our history, we are often the call and the location that receives the bulk of criminal things. When there's a conflict, when there's something that comes up, and they have certain areas of specialty, including child abuse material, online child abuse material, they have a specialty in that. And so those often originate with them. If they are with us, we often try to send them up there because of their area of expertise. But for terms of us, there's some provisions in here that I think the AG's office has probably commented on in terms of environmental law and civil law. The criminal aspects of this, the fraudulent land improvement would be something that really would fall likely in our area, but we'd certainly appreciate any assistance from concurrent prosecutors on these types of cases, because we do feel like we're at capacity.
But we come to the right department, it sounds like.
Yeah.
Right. Well, I think we'll stop there then. Thank you very much for joining us today, Tim, and I'm sure
You'll
you'll
come back.
Yeah, okay, well, if we need to, we'll reach out, but otherwise, thank you for your interest.
Thank you.
Yeah.
Good to see you all.
You too.
Thank you.
Stay healthy.
All right, we're all set.
Chip, do you know how many cases the